Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Have you ever been in a situation where you just knew you needed a lawyer? Maybe it was a dispute with a landlord, a confusing business contract, or something as simple as writing a will. And you made the call. You asked for the price. And then you felt that pit in your stomach. $300, $400, $500 an hour. Suddenly, your simple problem felt like a $10,000 problem. And you were faced with a choice that no one in a just society should ever have to make. Do I risk my financial future to get legal help? Or do I risk my legal rights and just hope for the best? For millions of Americans, that isn't a hypothetical. It's reality. Our legal system, the very foundation of our country, has become a luxury item. It's a gated community with a price of admission so high that 80% of the population can't afford it. But what if I told you that the walls of that community are about to be blown to pieces? What if I told you that a revolution is happening right now, not in a courtroom or in Congress, but in the server farms of Silicon Valley and the research labs of our top universities? A revolution powered by artificial intelligence, machine learning, and blockchain that is fundamentally rewiring the DNA of American law. This isn't a distant science fiction future. It's happening today. And by the end of this series, you will understand this new world better than 99% of the population, including most lawyers. This isn't just a video about cool new gadgets for attorneys. This is your guide to navigating a world where legal help is becoming democratized. We are going to show you how AI is already drafting contracts that are more ironclad than those written by a first-year associate at a top firm, for a fraction of the cost. We will reveal the new platforms that allow you to file a trademark, start an LLC, or even handle a small claims court case, all from your laptop, with guided intelligence that prevents you from making catastrophic mistakes. We're going to explore how technology is making the single most expensive part of any lawsuit, the discovery process, 1,000 times faster and cheaper. For you, this means access. It means power. It means that the next time you have a legal problem, that pit in your stomach won't be from fear of the cost, but from the confidence of knowing you have powerful, affordable tools at your fingertips. But this revolution isn't all sunshine and roses. With incredible power comes incredible risk. We will also pull back the curtain on the dark side of this transformation. We'll investigate algorithmic bias. What happens when the AI that helps determine bail or sentencing is prejudiced against certain communities? We'll dive deep into the massive privacy concerns that arise when every legal document you've ever signed is stored on a server, vulnerable to hackers. And we'll ask the terrifying question: what happens to the concept of innocent until proven guilty? When an AI can analyze every piece of data in your life and predict, with 95% accuracy, that you are going to commit a crime? This isn't just about convenience. It's about the future of our civil liberties. Understanding the technology is the only way to protect yourself and champion a future where justice is both accessible and fair. So why now? Why is this the single most important conversation we can be having about the American legal system? Because the money has arrived. In the last 3 years alone, venture capitalists have poured over $3 billion into something called legal tech. Giants like Google, Microsoft, and Thomson Reuters are in an all-out arms race to build the dominant legal AI. This isn't a niche industry anymore. It's a technological gold rush, and the landscape is changing so fast that legal regulations can't keep up. The decisions being made in boardrooms today will dictate the legal rights you have tomorrow. And if you don't understand the game, you're not a player. You're the product. Let's start with a real-world example that has already completely transformed the system, a change that happened so quietly most people never even noticed. It's a process called e-discovery, or electronic discovery. In the old days, and by old days I mean 15 years ago, if one massive corporation sued another, the process was almost comically inefficient. The lawsuit would begin, and both sides would have to hand over all relevant documents. This meant armies of young 20-something lawyers, fresh out of law school, would be sent to a windowless basement. Their job? To sit there for 16 hours a day for months on end, physically reading through millions of pieces of paper, emails, and internal memos one by one, looking for that one single sentence, that one smoking gun email that could win the case. It was a soul-crushing, mind-numbing task. And the cost? Astronomical. A single discovery phase in a major corporate lawsuit could easily cost $10, $20, even $50 million, with most of that money going to pay for those lawyers to read. It was a system that massively favored the side with the deepest pockets. If you were a smaller company suing a giant, they could just bury you in paperwork. They could discover you into bankruptcy before the case ever saw a judge. Justice wasn't about who was right. It was about who could afford to turn over the most rocks. Then everything changed. Software powered by machine learning came onto the scene. Instead of hiring 500 lawyers to sit in a basement, you could now feed all those millions of documents, terabytes of data, into a single program. You would train the AI. A senior lawyer would spend a few days showing it examples. This email is relevant. This one is not. This one contains privileged information. The AI would learn. And then it would do the work. It would analyze every single document, not in 6 months but in 48 hours. It didn't get tired. It didn't get bored. It didn't miss a key phrase on page 800,000 because it was on its 7th cup of coffee. It was faster, it was cheaper, and most importantly, it was more accurate. Study after study showed that the AI-powered review caught more relevant documents and made fewer mistakes than the human teams it replaced. This wasn't just an improvement. It was a paradigm shift. The $50 million problem became a $500,000 problem. It leveled the playing field, allowing smaller players to take on giants without fear of being bankrupted by the process itself. E-discovery is now the industry standard. It's used in virtually every significant civil and criminal case in America. It is the perfect, silent example of how technology has already fundamentally altered the balance of power in our legal system. It took a process that was opaque, impossibly expensive, and biased toward the rich, and made it faster, more affordable, and more democratic. But that was just the beginning. That was technology learning how to read the law. The next phase, the one we are entering right now, is far more profound. Because the technology is no longer just reading. It's learning how to write. It's learning how to reason. It's learning how to argue. So, if an AI can already analyze 1 million documents more effectively than a team of Harvard Law graduates, what happens when that same AI starts drafting the legal motions? What happens when it starts predicting a judge's ruling based on their entire legal history? And what happens when it's no longer just a tool in the background, but the primary legal advisor for millions of Americans? That's where this is all going. And the implications will change everything. To understand how, let's leave the courtroom for a moment and go to a small bakery in Austin, Texas. Meet Maria, a single mom who poured her life savings into a gluten-free cupcake business. Her logo, a stylized wheat stalk bent into a heart, was her pride and joy. Then the letter arrived. It was from a multi-billion-dollar agricultural conglomerate. Thick, cream-colored paper, embossed letterhead. A cease and desist. They claimed her little heart-shaped logo was confusingly similar to their registered trademark. They gave her 14 days to rebrand everything, or they would sue her into oblivion. Maria's heart sank. She called a lawyer. The consultation fee alone was more than her weekly profit. The lawyer quoted her a retainer of $10,000 just to start, with no guarantee of success. It was an impossible choice. Give up the brand she built from scratch, or fight a legal battle that would bankrupt her before it even began. This is the reality of the American justice system for millions. It's not about who is right, it's about who can afford to stay in the fight. But this isn't 2014. It's today. Distraught, Maria typed her problem into a search engine, and she found a third option. A website offering AI-powered legal assistance for a flat fee of $99. Skeptical but desperate, she paid. She uploaded the cease and desist letter. Within 30 seconds, the system analyzed the document. It identified the specific trademark statute the conglomerate was citing. Then it cross-referenced their claims against a database of tens of thousands of similar trademark disputes across the entire country. The AI delivered its report. It concluded the conglomerate's claim was weak. It cited 3 specific federal court cases where similar claims by large corporations against small businesses were dismissed. It highlighted the key differences between her logo and theirs. Differences a human lawyer might take days to research and articulate. Then the AI did something that felt like magic. It drafted a response letter. It was professional, firm, and legally dense, quoting the exact precedent it had just found. It laid out, in excruciating detail, precisely why their claim had no merit, and stated her intent to continue using her logo. All Maria had to do was put her name on it and send it. She sent the letter. And she waited. 2 weeks later, she got a one-sentence email from the conglomerate's legal department. They were withdrawing their claim. The fight was over. Total cost to Maria: $99. This story isn't a futuristic fantasy. It's happening right now in every state. This is the promise of technology and law, the democratization of justice. For the first time in history, the immense power of legal research and strategy, once locked away in mahogany-paneled offices and accessible only to the wealthy, is being handed to the masses. Think about what this means. It's not just for small business owners. It's for tenants fighting an illegal eviction. It's for parents trying to navigate a complex child custody agreement. It's for someone trying to expunge a minor criminal record that's holding them back from getting a job. These platforms are leveling a playing field that has been tilted for centuries. They are giving a voice to the voiceless and a fighting chance to those who would otherwise have to fold. Companies like Do Not Pay, which started as a way to fight parking tickets, now brands itself as the world's first robot lawyer, helping users with everything from suing corporations in small claims court to securing refunds from airlines. Other platforms are focused on specific areas like contract review. You can upload a 50-page apartment lease or a freelance work agreement, and in moments, an AI will highlight predatory clauses, suggest changes, and explain complex legal jargon in plain English. This is a revolution. But every revolution has casualties, and every powerful new tool has a dark side. The question is, who is responsible when the robot lawyer makes a mistake? When Maria used that AI, she clicked a box agreeing to a massive wall of text called the Terms of Service. Buried in that text was a clause stating that the service is not providing legal advice, that it is not a law firm, and that it bears zero liability for any errors or omissions. So what if the AI had been wrong? What if it had missed a key precedent and Maria, following its advice, had been sued and lost everything? Who would she blame? She can't sue the AI. And the company that created it is shielded by the very legal language their own systems are designed to navigate. She would be left with nothing, a victim of an algorithm's mistake with absolutely no recourse. This is the central paradox. We're creating tools that offer unprecedented access to justice, but they exist in a legal gray area, operating without the oversight, insurance, and ethical obligations that a human lawyer is bound by. A human lawyer can be disbarred for malpractice. What do you do to a piece of software? Unplug it? This is already creating chaos in the court system. The number of people representing themselves in court, known as pro se litigants, is exploding. And now, they're not coming in empty-handed. They're armed with AI-generated motions, briefs, and arguments. Judges are seeing filings that are strangely eloquent, perfectly formatted, yet sometimes nonsensical. AI models are notorious for hallucinating, confidently making up facts or, in this case, legal precedents. There have been documented cases of lawyers and pro se litigants submitting briefs to a judge that cite entirely fictional court cases created by an AI. Imagine being a judge. You have a duty to give a fair hearing to everyone, including those who can't afford a lawyer. But now you're faced with a litigant who is essentially a mouthpiece for a machine that might be brilliant one moment and a pathological liar the next. How do you manage a courtroom like that? Do you need to start fact-checking every single citation an unrepresented person brings before you? The system is already overloaded. This threatens to grind it to a halt. Naturally, the legal establishment is terrified, not just of the chaos but of the existential threat. For centuries, the law has been a guild, a closed system protected by bar exams, state licensing, and complex rules designed to ensure only qualified humans could practice. They argue this is for public protection, and they have a point. A lawyer does more than just research cases. They understand nuance, they counsel their clients, they read the mood of a courtroom, the expression on a judge's face. They practice the art of law, not just the science. But many outside the guild see it differently. They see a monopoly, a system designed to protect high hourly rates and limit competition. Now, technology is a battering ram at the gates of that monopoly. Bar associations across the country are scrambling, trying to figure out how to respond. Some are trying to ban these tools, arguing they constitute the unauthorized practice of law. Others are trying to find ways to regulate them, to build ethical guardrails around this new technology before it's too late. But the pace of technological change is relentless. It's outpacing any attempt to regulate it. While committees debate the ethics, new, more powerful AI legal models are being released every month. The genie is not going back in the bottle. The power is already in the hands of the people. But this empowerment brings a terrifying new risk. We've democratized the tools, but in doing so, have we accidentally created a two-tiered system of justice? One for those who can afford a human lawyer with instincts and accountability, and another for everyone else, guided by algorithms we don't fully understand? And what happens when those algorithms, trained on a justice system with a long and troubled history, start to show bias? This is the fundamental, terrifying paradox of artificial intelligence in the law. We look to machines for objectivity, hoping they can save us from our own flawed human nature. But these machines aren't born in a vacuum. They are trained. They learn. And what are we teaching them? We are feeding them our history. We are giving them decades, even centuries, of data from the American justice system. Every arrest report, every plea bargain, every sentencing decision, every parole hearing. We are asking the AI to find patterns in this data and use those patterns to predict the future. And it does. It finds the patterns with ruthless efficiency. But what happens when the patterns themselves are the product of bias? What happens when the data is a reflection not of pure criminality, but of a society that has, for generations, policed, prosecuted, and punished different communities in vastly different ways? The machine doesn't know the history of redlining, or the war on drugs, or mandatory minimums that disproportionately affected minority communities. Just sees the data. It sees that people from a certain zip code, or of a certain race, are arrested more often and receive longer sentences. And so, it learns a simple, brutal lesson: people who look like that, who live there, are higher risk. It's a concept computer scientists have a simple name for: garbage in, garbage out. If you train an algorithm on biased data, you will get a biased algorithm. It's not magic. It's math. And this isn't a hypothetical dystopian future. It's happening right now in courtrooms all across America. The most famous, or perhaps infamous, example is a piece of software called Compass. It's a risk assessment tool used by judges to help determine everything from bail amounts to prison sentences. It analyzes a defendant's history and answers 137 questions to generate a score, predicting how likely they are to commit another crime. For years, this was seen as a step forward, a data-driven way to make more informed decisions. Then, in 2016, the investigative journalism outlet ProPublica decided to look under the hood. They analyzed the risk scores given to more than 7,000 people arrested in Broward County, Florida. What they found was staggering. The algorithm was almost twice as likely to falsely label black defendants as high risk for future crimes as it was white defendants. Let me repeat that. Even when they controlled for prior crimes, future recidivism, and the type of crime, the racial disparity remained. The individual stories were even more damning. A black woman named Bresha Borden, who was 18, was rated as a high risk. Her crime? She and a friend had taken a kid's bike and scooter, a foolish act of petty theft. She had a record of misdemeanors as a juvenile. A 41-year-old white man named Vernon Prater was rated as a low risk. His crime? Shoplifting tools worth less than $100. But he had a record that included 2 armed robberies. The algorithm saw Bresha Borden as the bigger threat. The algorithm was wrong. 2 years later, Borden hadn't been charged with any new crimes. Vernon Prater, the low-risk offender, was serving an 8-year prison sentence for a subsequent armed robbery. The system got it backwards. And it wasn't an isolated incident. ProPublica found that white defendants who were labeled low risk went on to commit new crimes far more often than black defendants who were also labeled low risk. The company that created the software, NorthPoint, fired back. They claimed their algorithm was fair, that it correctly predicted recidivism at roughly the same rate for both black and white defendants. And this is where it gets truly complicated. How can both be true? How can the algorithm be both racially biased and equally accurate? It's because they were arguing about the very definition of fairness. ProPublica was looking at the rate of false positives, incorrectly flagging someone as high risk. NorthPoint was looking at overall predictive accuracy. It's a mathematical and philosophical minefield, proving that you can use statistics to argue almost any point. But for the defendant standing in front of a judge, this academic debate means nothing. What matters is that a secret proprietary algorithm, a black box, has labeled them, and that label can change their life. This is the black box problem, and it strikes at the very heart of American due process. The Sixth Amendment guarantees a defendant the right to confront their accuser, to examine the evidence against them. But how do you cross-examine an algorithm? How do you challenge evidence when the formula that produced it is a trade secret, hidden from you, your lawyer, and even the judge? You can't. You are being judged by a silent witness whose testimony you are not allowed to question. This isn't just a concern in criminal courts. Algorithmic bias is seeping into every corner of the legal world. Major law firms now use AI to screen thousands of resumes for summer associate positions. If a firm has a history of hiring predominantly from Ivy League schools, what do you think the AI will learn? It will learn to value a degree from Harvard over one from a state school, regardless of the individual applicant's talent. It will learn to replicate the firm's existing biases, creating a high-tech barrier to entry for anyone who doesn't fit the traditional mold. In civil law, AI is used to predict the outcomes of personal injury cases, which then dictates settlement offers. But what if the historical data shows that women, or people of color, have historically been awarded less money for the same injuries? The AI will learn this pattern. It will see a female plaintiff and calculate a lower probability of a high payout, leading the insurance company to offer her a smaller settlement. The bias of the past becomes a self-fulfilling prophecy for the future, all laundered through the seemingly neutral language of data and probability. Perhaps most chillingly, these tools are being used in family law and child protective services. Algorithms are now being deployed in some counties to predict which children are at the highest risk of abuse or neglect. But where does that data come from? It often comes from records of families who have interacted with public services, like welfare, public hospitals, or Medicaid. These are, by definition, overwhelmingly low-income families, who are also disproportionately families of color. The algorithm doesn't see poverty. It sees a statistical correlation between using public services and being reported for neglect. It learns to flag poverty as a risk factor, potentially leading to social workers knocking on the door of a struggling family, not because of evidence of abuse, but because of a computer's cold calculation. This is the ultimate danger. These systems don't just reflect our biases. They amplify them. They codify them. A human judge may be biased, but their decisions are, to some degree, individualized. They can be appealed, and another judge might see things differently. But an algorithm applies its bias universally, at an unimaginable scale, to every single case it touches. It creates a devastating feedback loop. The algorithm predicts a certain neighborhood is high risk, so police patrol it more heavily. More patrols lead to more arrests for minor infractions. These new arrests are then fed back into the system as data, which proves to the algorithm that its initial prediction was correct. The bias becomes entrenched, validated by the very actions it inspired, and disguised as objective truth. So we have a system that's supposed to be blind now being guided by a black box that is anything but. It's a silent judge, operating behind a screen of code, and its judgments are shaping real lives right now. The question is no longer if technology has a bias problem, but what in the world we are going to do about it, before this digital ghost in the machine becomes the final word on American justice. But what happens when that ghost steps out of the shadows? When it's no longer just a silent arbiter of our fate, but an active participant in our legal battles? What happens when the machine puts on a tie, sits across the table from you and says, "I'm here to help"? This isn't science fiction. This is the dawn of the robot lawyer, and it's forcing America to ask a terrifying and exhilarating question. Can justice be coded? The story of the robot lawyer, for many, begins with a teenager annoyed by parking tickets. In 2015, a Stanford student named Joshua Browder created a simple chatbot he called Do Not Pay. Its mission was brilliant in its simplicity: help people fight unfair parking fines by automatically generating appeal letters. It was a massive viral success. Millions of dollars in fines were overturned. It was a classic David versus Goliath story, with a little bit of code as the slingshot. But Browder's ambition didn't stop at parking tickets. He branded Do Not Pay as the world's first robot lawyer, and its scope exploded. Suddenly, it promised to help you sue anyone in small claims court with the press of a button, get refunds from airlines, cancel gym memberships, and even help asylum seekers navigate the labyrinthine U.S. immigration system. The ultimate goal? To have an AI whisper legal arguments into a defendant's ear, live, in a real American courtroom. The appeal is undeniable, because it targets one of the most fundamental and painful failures of the American legal system: access. We have a system of laws designed to protect everyone, but in practice, justice often comes with an astronomical price tag. The average lawyer in the U.S. charges over $300 an hour. For a complex case, you could be looking at tens, even hundreds of thousands of dollars. The result is what legal experts call the justice gap. The Legal Services Corporation found that in a single year, low-income Americans did not get any, or enough, legal help for 92% of their substantial civil legal problems. Think about that. For nearly every problem, an illegal eviction, a wage dispute with a crooked boss, a medical debt collection agency harassing your family, the vast majority of people are left to fend for themselves. They are outgunned, outmaneuvered, and overwhelmed by a system they cannot afford to navigate. Into this crisis steps the robot lawyer, promising to be the great equalizer. It offers a solution that isn't $100 an hour, but maybe $10 a month. It promises to democratize the law, to put a powerful tool in the hands of the powerless. For someone facing a small claims court battle against a landlord over a security deposit, the choice between spending $2,000 on a lawyer or using a cheap app is no choice at all. This is the utopian vision of legal tech. A world where legal help isn't a luxury for the rich, but a basic utility available to everyone with a smartphone. It's a powerful, seductive promise. But as these robot lawyers grew more ambitious, a much darker and more complicated reality began to emerge. And it centers on three words that are the bedrock of legal ethics: unauthorized practice of law. In every state, it is illegal to provide legal advice unless you are a licensed attorney who has passed the bar exam. This isn't just bureaucratic gatekeeping. It's a consumer protection law. It ensures that the person guiding you through a life-altering legal issue is competent, ethical, and accountable. And this is where the robot lawyers ran into a wall of fire. Class action lawsuits began to pile up. The core allegation: that these services weren't just sophisticated form fillers. They were providing legal advice. They were analyzing facts, suggesting legal strategies, and generating legal documents. All things that constitute the practice of law. And according to the lawsuits, they were often doing a terrible job. The documents they produced were allegedly riddled with errors, citing non-existent case law, or were completely inappropriate for the user's situation. Imagine relying on an AI to draft your will, only for your family to discover after you're gone that it's legally invalid because the bot missed a key requirement in your state's probate code. Or imagine using an app to sue your old employer, only to have the case thrown out because the robot filed the wrong motion in the wrong court. Suddenly, the promise of cheap, easy justice turns into a nightmare of missed deadlines, lost cases, and irreversible harm. This raises a question that our legal system is completely unprepared to answer. Who is responsible? When a human lawyer commits malpractice, the path is clear. You can sue them. You can report them to the state bar, which can suspend or revoke their license to practice. They have malpractice insurance. There is a system of accountability built over centuries. But who do you sue when your robot lawyer messes up? Do you sue the software company? What if their terms of service, the ones you scrolled past and clicked agree on, say they're just an information service and not responsible for any outcomes? Do you sue the individual programmer who wrote the faulty code? Good luck finding them. The AI is a black box, and the company that owns it is often hidden behind layers of corporate shielding and legal disclaimers. The robot lawyer offers you power, but it asks for almost no accountability in return. This goes even deeper than just legal liability. It cuts to the very heart of what a lawyer truly does. The best lawyers are not just walking encyclopedias of legal statutes. They are counselors, strategists, and storytellers. A great lawyer can read a room. They can see the flicker of doubt in a witness's eye, sense a judge's growing impatience, or connect with a jury on a deeply human level. They provide not just legal advice, but emotional counsel. They can calm a panicked client, manage expectations, and provide a steady, human presence during the most stressful time in a person's life. Can an algorithm show empathy? Can a large language model understand the nuance of a shaky voice or a defiant posture? It can process millions of pages of case law in a second, but it cannot replicate the wisdom gained from thousands of hours spent face-to-face with human beings in crisis. It can generate a logical argument, but it cannot tell a story that moves a jury to tears or to righteous anger. The practice of law is, and has always been, a profoundly human endeavor. And the danger of outsourcing it to a machine isn't just that the machine will make mistakes, but that we will lose something essential in the process, the very humanity at the center of justice. The battle lines are being drawn. These AI legal services aren't going away. They're getting smarter, more powerful, and better funded every day. State bar associations across the country are scrambling to figure out how to regulate this new frontier without stifling innovation that could genuinely help people. Law schools are starting to wonder if they need to teach their students prompt engineering alongside civil procedure. The question is no longer if AI will be a part of the legal world, but what part it will play. Will it remain a tool, a sort of super paralegal, augmenting the abilities of human lawyers to make them faster, cheaper, and more efficient? Or will it become something else entirely? A new unregulated class of legal practitioner, operating in a gray area of the law with immense power and little oversight? The courtroom of the future might not be human versus human. It might be a human lawyer, augmented by their own private AI, facing off against another. And the winner won't just be the one with the better argument, but the one with the better machine. The question we have to answer is that a future we're prepared for? Because the truth is, we're not prepared. Not even close. We're so focused on the sci-fi image of a robot lawyer in a courtroom, we're missing the revolution that's already happening. It's not taking place in the hallowed halls of the Supreme Court, but in the chaos of everyday life. It's happening on our phones, in our homes, and for millions of Americans, it's not a choice. It's the only option they have. Because before we can even talk about AI lawyers for the rich, we have to talk about the catastrophic failure of the legal system for everyone else. It's called the justice gap. And it's the Grand Canyon of American society. Imagine you're being illegally evicted by your landlord. Or you're a small business owner being sued by a massive corporation. Or maybe you're buried in medical debt after an accident that wasn't your fault. You need a lawyer. But a lawyer costs on average over $350 an hour. So you look for help. You call legal aid, but they tell you that you make too much money to qualify. You're trapped in the middle. You're not poor enough for free help, but you're nowhere near rich enough to afford a lawyer. This isn't a rare scenario. This is the reality for the vast majority of Americans. A recent study found that a staggering 92% of low-income Americans do not get any or enough legal help for their civil legal problems. 92%. That's not a gap. It's an abyss. It's a quiet crisis where people lose their homes, their children, and their livelihoods not because they're wrong, but because they can't afford to prove they're right. For decades, the legal profession's answer to this was, well, there wasn't one. The system was the system. But then technology started to pry open the door. The first wave was subtle. Companies like LegalZoom and Rocket Lawyer appeared online. Suddenly, for $100, you could create a will, incorporate a business, or draft a lease agreement. It was revolutionary. It took tasks that were once locked inside expensive law firms and turned them into a consumer product. It was the legal equivalent of learning to change your own oil instead of paying a mechanic. It empowered people. It gave them a sense of control over their own legal destinies. For simple, straightforward tasks, it was a game changer. But it was also a band-aid on a bullet wound. These services are great at providing documents, but they're legally forbidden from providing advice. They can give you the template for a will, but they can't tell you if that's the right kind of will for your complicated family situation. They can help you file the paperwork for an LLC, but they can't advise you on the tax implications. It created a new kind of danger, the illusion of safety. You could fill out all the forms perfectly, check all the boxes, and still be setting yourself up for a legal disaster down the road, all because you didn't know the one critical question you were supposed to ask. The system was still fundamentally broken. People didn't just need cheaper forms, they needed cheaper guidance. And that's when the second wave of technology hit, the one that truly terrified the legal establishment. A new breed of startups began to emerge, armed with code and a mission to automate justice itself. The most famous and most controversial was a company called Do Not Pay. It started with a simple, brilliant idea: a chatbot that could help you fight parking tickets. The founder, a college student, realized the process was just a series of formulas and rules, perfect for an algorithm. The app would ask you a series of questions, and based on your answers, it would generate a legally sound appeal letter. And it worked. It reportedly overturned hundreds of thousands of tickets, saving users millions of dollars. It was a robot lawyer in your pocket, fighting the faceless bureaucracy on your behalf. From there, it expanded. The app promised to help you sue companies in small claims court, cancel unwanted subscriptions, and even get airline refunds. It was David's digital slingshot against a world of Goliaths. For the first time, technology wasn't just giving you a form to fill out. It was guiding you through a process. It was analyzing your problem and suggesting a path forward. It was walking right up to the line of giving legal advice, and in the eyes of the legal world, it was jumping right over it. And the legal world punched back hard. The entire American legal system is built on a set of rules called the Unauthorized Practice of Law, or UPL. These laws, which vary by state, essentially make it a crime for anyone but a licensed attorney to give legal advice. The original intent was noble, to protect the public from unqualified charlatans and scam artists. But in the 21st century, these century-old rules have become a wall, protecting the legal profession's monopoly. They've been used not just to stop scammers, but to shut down innovators who are trying to make the law more accessible. Do Not Pay and other legal tech companies found themselves in the crosshairs. They were hit with class action lawsuits, accused of violating UPL statutes. The argument was that their software, their robot lawyer, was practicing law without a license. Think about how crazy that is. A profession that has failed to serve 92% of the people who need it is actively suing the very technology that's trying to help them. It's like the taxi industry suing Uber. But instead of protecting fares, they're protecting a system that leaves most people stranded on the side of the road. This fight forces us to ask a fundamental question. What even is legal advice anymore? If an app takes publicly available information about landlord-tenant law and organizes it into a step-by-step guide for a tenant-facing eviction, is that illegal? If a piece of software helps you fill out a complex government benefit form, a form designed to be used by the public, is that practicing law? The old definitions are crumbling. The line between providing information, which is legal, and providing advice, which is not, has become hopelessly blurred by technology. And while lawyers and tech CEOs battle it out in court, real people are caught in the middle. The single mom trying to get child support, the elderly couple trying to stop debt collector harassment, the immigrant trying to navigate the visa process. They don't care about the legal definition of advice. They just need help. They need a system that doesn't require a $5,000 retainer just to get a foot in the door. Technology offers that promise. It offers a future where basic legal help is not a luxury for the wealthy, but a utility accessible to everyone, like water or electricity. A world where your rights don't depend on the size of your bank account. The technology is here. The algorithms can be written. The apps can be built. We have the tools to begin closing the justice gap, to start leveling the playing field between the powerful and the powerless. The only thing standing in the way isn't a technical problem. It's a human one. It's a system fighting to protect its own traditions, its own power, and its own profits, even at the expense of the very people it's supposed to serve. So we have the technology to build a more just America. The real question is, does the legal profession have the will to let us? To answer that, you have to understand that the American legal system isn't just a system of justice. It's a multi-billion-dollar industry. And like any industry, its first instinct is self-preservation. This isn't some grand conspiracy. It's a collection of deeply ingrained structures, rules, and economic models that have evolved over centuries, all designed to do one thing very, very well: protect the profession. And the single most powerful, most entrenched, and most anti-technological of these structures is a deceptively simple concept: the billable hour. For most of us, when we buy a service, we pay for a result. You pay a plumber to fix the leak. You pay a mechanic to fix your car. But in large swaths of the legal world, you don't pay for the result. You pay for the time, 6-minute increments to be exact. Every phone call, every email, every minute spent thinking about a case is meticulously logged and billed. This model was born in an analog era, a time when a lawyer's primary asset was indeed their time, spent in a physical library, poring over dusty books. In that world, it made a certain kind of sense. But in the digital age, the billable hour has become a golden handcuff. It creates a fundamentally perverse incentive. It rewards inefficiency. The longer a task takes, the more money a lawyer makes. Think about that. The legal profession is one of the only industries on earth where making your process slower and more complicated directly increases your revenue. Now introduce a piece of technology that can do a week's worth of work in an afternoon. Let's say you're a large corporation involved in a lawsuit. The discovery phase begins, which means you have to sift through hundreds of thousands of internal documents, emails, memos, reports, to find anything relevant to the case. The old way, a team of a dozen junior associates sits in a room for weeks, billing hundreds of dollars per hour per person to manually read every single document. It's mind-numbing work, prone to human error, and astronomically expensive. The final bill can easily run into the hundreds of thousands or even millions of dollars. The new way, AI-powered e-discovery software. You feed the documents into the system, give it some parameters, and it uses machine learning to analyze, categorize, and flag the relevant files in a matter of hours. It's faster, more accurate, and orders of magnitude cheaper. So which system do you think a law firm built on the billable hour model is going to prefer? The one that generates $1 million in fees, or the one that generates 50,000? The technology presents an existential threat to their entire business model. It's not that lawyers are bad people. It's that they are rational actors in a system that punishes them for being efficient. Adopting technology that dramatically cuts down on time is like asking a turkey to vote for Thanksgiving. This economic resistance is then fortified by a legal wall, a regulatory moat designed to keep outsiders out. It's called the Rule Against the Unauthorized Practice of Law, or UPL. On the surface, it sounds perfectly reasonable. We don't want someone with no training giving people bad legal advice that could ruin their lives. It's meant to protect the public from harm. But in practice, UPL rules have been weaponized by state bar associations, which are run by lawyers for lawyers, to crush competition and stifle innovation. These rules are often incredibly broad and vague. What exactly constitutes legal advice? If a website helps you fill out a standardized divorce form based on your answers to a questionnaire, is that legal advice? If an app analyzes your rental agreement and flags potentially illegal clauses, is that legal advice? Tech companies and entrepreneurs who have tried to build these kinds of affordable tools for the public have found themselves in a legal minefield. They've been hit with cease and desist letters and crippling lawsuits, not from unhappy customers, but from the bar associations themselves, acting as the enforcers of the guild. Look at the history of a company like LegalZoom. For years, they fought state-by-state battles just for the right to offer automated legal documents to the public. The argument from the legal establishment was that these services were a dangerous substitute for a real lawyer. But for millions of Americans who can't afford a real lawyer in the first place, the alternative isn't a $500 an hour attorney. The alternative is nothing. The UPL rules, in effect, create a state-sanctioned monopoly that ensures if you want any form of legal help, you have to go through the official expensive gatekeepers. This has a massive chilling effect. Why would a venture capitalist invest millions into a brilliant legal tech startup that could be sued into oblivion by the North Carolina State Bar? The result is that the people who need help the most, the ones caught in the justice gap, are the ones who are protected right out of having any options at all. But the resistance isn't just economic or regulatory. It's cultural. It's baked into the very institution of the courts. While the rest of the world has moved at the speed of light, many of our court systems have remained stubbornly, almost proudly, analog. Until the pandemic forced their hand, the idea of a remote hearing via Zoom was seen as a radical, undignified experiment in many jurisdictions. We still have courts that demand documents be filed in triplicate, on paper, delivered by hand. We have judges who openly admit they don't understand how email or social media works, who then preside over complex cases involving digital evidence and intellectual property. This isn't just a quaint quirk of an old institution. It has devastating real-world consequences. Evidence is mishandled. Cases are delayed for years because of archaic scheduling and filing systems. Rulings are made based on a fundamental misunderstanding of the technology at the heart of a dispute. There's a deep-seated cultural skepticism, a belief that true justice can only be administered in a wood-paneled room, with stacks of paper, following procedures that haven't changed much in 100 years. Technology is seen not as a tool for efficiency and access, but as a threat to the solemnity and tradition of the law. Now, to be fair, this resistance isn't born entirely of self-interest and technophobia. There are legitimate, thorny, and deeply serious ethical questions that come with integrating advanced technology, especially artificial intelligence, into the legal system. The most significant of these is the black box problem. When a lawyer makes an argument, they have to show their work. They cite precedents, they build a logical chain of reasoning, and they present it to a judge. But many of the most powerful AI models are black boxes. They can analyze millions of data points and deliver a startlingly accurate conclusion, like predicting the likely outcome of a bail hearing or identifying the best legal strategy. But they can't always explain how they reached that conclusion. The reasoning is buried in a complex web of algorithms that even its own creators may not fully understand. How can a judge accept a legal argument from a machine that can't explain its own logic? How can you cross-examine an algorithm? Worse yet is the problem of bias. An AI is only as good as the data it's trained on. If you train an AI on decades of historical sentencing data from the American criminal justice system, what do you think it's going to learn? It's going to learn the systemic biases that are already baked into that data. It will learn that certain neighborhoods, certain demographics, are associated with higher rates of conviction or longer sentences. In 2016, a groundbreaking ProPublica investigation revealed that a risk assessment algorithm being used in courtrooms across the country was falsely flagging black defendants as future criminals at nearly twice the rate as white defendants. The algorithm, intended to remove human bias, had instead absorbed it, codified it, and given it a terrifying veneer of objective mathematical certainty. So we're caught in a paradox. The very tools that could fix our broken system are being blocked by that system's gatekeepers, who are using both self-interest and legitimate caution as their shield. The billable hour incentivizes inefficiency. UPL rules create a protectionist monopoly. The courts themselves are mired in tradition. And the technology itself, for all its promise, carries the risk of amplifying our worst biases and undermining the very principles of explainable justice. The question is no longer if technology can change the law, but who will control that change? Will it be the innovators trying to build a new system from the outside in? Or will it be the establishment, slowly and reluctantly bolting new gadgets onto an ancient, crumbling machine? The answer will determine what justice in America looks like for the next 100 years. To answer that, let's first walk through the gilded doors of the establishment. Picture it: a law firm on the 50th floor of a Manhattan skyscraper. The air smells of old leather and money. The walls are lined with mahogany, covered in degrees from Harvard and Yale. This is the fortress of American law, a place where tradition isn't just respected, it's weaponized. For decades, the primary technology in these halls was the telephone and the dictaphone. The model was simple: hire the smartest people, work them to the bone, and charge clients a small fortune for every 6-minute increment of their time. Now, into this world technology has arrived, but it hasn't arrived like a conquering hero. It's crept in like an awkward intern, unsure of where to stand. The establishment isn't rebuilding the system, it's patching it. They're bolting on new gadgets, but only the ones that don't threaten the fundamental structure. Think of legal research. It used to be an army of young associates buried in a law library for a week, surrounded by dusty, leather-bound books, searching for that one obscure precedent. The firm would bill the client for every single one of those hours. Today, that same associate can use a platform like Westlaw or LexisNexis and find the same precedent in 20 minutes. It's a miracle of efficiency. But here we run headfirst into the single greatest obstacle to technological innovation in the legal world: the billable hour. The entire business model of elite law is built on selling time. Not results, not solutions, not efficiency, time. So what happens when a piece of software can do a 10-hour task in 10 minutes? From the client's perspective, it's a massive win. But from the law firm's perspective, they've just lost 9.8 hours of billable revenue. That's not an innovation, it's a catastrophe. This isn't a bug in the system. It's the central feature. The incentive structure is fundamentally, diametrically opposed to efficiency. The more inefficiently a firm can work on your problem, the more money they make. This creates a bizarre internal conflict. You have young tech-native associates who can use artificial intelligence to review 1,000 contracts in an afternoon, but they're being told by a senior partner to slow down, to do it the old way, to be more thorough, which is often code for be more billable. The firm buys the expensive software to put on their marketing brochures, to show clients they're on the cutting edge. But internally, they discourage its most powerful time-saving uses. They've bought a race car and put a governor on the engine so it can't go over 30 miles per hour. One area where big law has been forced to embrace technology is e-discovery. In the old days, discovery, the process of exchanging information before a trial, meant going through boxes and boxes of paper documents. Today it means sifting through petabytes of data. A single lawsuit against a major corporation can involve millions of emails, Slack messages, text messages, voicemails, and server logs. No army of humans could ever review all of that. So, multi-million-dollar software platforms were born. These tools use AI and machine learning to scan for keywords, identify privileged communications, and flag relevant documents. This sounds like a leap forward, and in some ways it is. But it has also turned discovery into an obscenely expensive, high-tech arms race. Firms now have to hire specialized e-discovery vendors, forensic data experts, and project managers. The technology, instead of simplifying the process, has added new layers of complexity and cost. It solved the problem of scale, but created a new problem of technological warfare, with each side using sophisticated software to try and bury the other in digital paperwork. The billable hour is safe because now lawyers can bill for the hours spent managing the software that was supposed to save them hours in the first place. This is the establishment's pattern. They adopt technology defensively. Another prime example is cybersecurity. Law firms are treasure troves of sensitive information. They hold the secret plans for corporate mergers worth billions, the patent designs for revolutionary new products, the litigation strategies that could sink a Fortune 500 company. That makes them a massive target for hackers. In the last decade, some of America's most prestigious firms have been hit by devastating cyber attacks, with hackers stealing data and demanding ransom. In response, these firms have been forced to spend astronomical sums on cybersecurity. They're hiring former NSA agents, building secure data centers, and implementing multi-factor authentication for everything. This is a massive technological investment, but notice the motivation. It's not about delivering better, faster, or cheaper legal services to their clients. It's about survival. It's about protecting the fortress. They are building higher walls and deeper moats, not designing a better way to live. The technology serves to reinforce the old model. The firm is a secure vault of secrets that you pay a premium to access. And if the private sector is a fortress, the public court system is a crumbling shack with a brand new padlock. The judiciary, the very heart of our legal system, is tragically and dangerously behind the curve. While big law firms debate the ethics of generative AI, many local courts are still struggling to implement basic e-filing systems that were common in other industries 20 years ago. We have a system where a lawyer in a glass tower in New York can use a supercomputer to analyze a case, but when they need to file a motion in a rural county courthouse, they might literally have to send it via fax machine. Or worse, drive 3 hours to hand a piece of paper to a clerk. This digital divide in our justice system is not just an inconvenience. It's a crisis. Courts are overwhelmed, underfunded, and technologically illiterate. During the pandemic, we saw this firsthand. Courts that had resisted video conferencing for decades were suddenly forced to hold hearings over Zoom. And while it was a chaotic and often clumsy transition, it revealed something incredible. It worked. A single mother didn't have to take a day off work and find childcare to show up for a 5-minute traffic court hearing. A small business owner could attend a procedural hearing from their office instead of losing half a day in transit. Access to justice for a brief moment actually increased for many people. But as the world returned to normal, what did many of these courts do? They went right back to the old way. They went back to demanding that people physically appear for matters that could easily be handled remotely. Why? Because the institution of the court is built on physical presence, on ancient rituals of standing before a judge in a specific room. The technology was treated as a temporary patch, not a permanent upgrade. The crumbling machine was given a jump start, but no one wanted to replace the engine. So the establishment, both the wealthy private firms and the impoverished public courts, is changing, but at a glacial pace. They are adopting technology where it is absolutely necessary for survival or where it can be twisted to support the existing, wildly profitable, and deeply inefficient business model. They are bolting a jet engine onto a horse-drawn carriage. It makes a lot of noise, costs a fortune to run, and is terrifying for the horse, but it's not fundamentally changing the fact that it's still a carriage. The real question is, what happens when someone else shows up with a car? What happens when the disruptors don't just offer a faster horse, but an entirely new form of transportation? Because they're not just coming, they're already here. And they aren't trying to patch the system. They're building a new one right next to it. This new system isn't being built in the hallowed halls of justice, or the mahogany-paneled offices of century-old law firms. It's being coded in Silicon Valley, beta-tested in Salt Lake City, and rolled out from servers in the cloud. The architects of this new world aren't lawyers in pinstripe suits. They're software engineers in hoodies, and their client isn't a person, it's a user. For decades, the first wave of this change looked relatively harmless. Companies like LegalZoom and Rocket Lawyer emerged, offering a simple, powerful proposition. Why pay a lawyer $2,000 to incorporate your small business when you can fill out an online form and do it for a few hundred? Why spend a fortune on a simple will when a template can get you 90% of the way there? To the legal establishment, this was an annoyance. It was the commoditization of low-level, routine work. They saw it as the fast food version of a gourmet meal, quick, cheap, but lacking the substance and quality of the real thing. And for a while they were right. These services were great for simple boilerplate needs, but for anything complex you still needed a lawyer. They were the faster horse, not the automobile. But the second wave is different. The second wave is powered by the same force that's reshaping everything else: artificial intelligence. We're not just talking about digital forms anymore. We're talking about platforms that can analyze thousands of contracts in minutes, flagging risky clauses a junior associate might miss. We're talking about AI-powered research tools that can sift through centuries of case law to find the perfect precedent, a task that once took days of expensive, billable hours. We're talking about predictive analytics that can forecast the likely outcome of a lawsuit with startling accuracy, changing the entire calculus of whether to settle or fight. This is the new form of transportation, and it's not just faster. It operates on a completely different set of principles. This has ignited a fierce, existential battle, and the battlefield is the very soul of the American legal system. On one side, you have the disruptors. They point to a devastating statistic known as the justice gap. Study after study shows that 80 to 90% of the legal needs of low-income Americans go unmet. Even for the middle class, hiring a lawyer for a divorce, a custody battle, or a dispute with a landlord can be financially catastrophic. The tech companies argue they are solving this crisis. They are democratizing the law, using technology to make legal help affordable and accessible for the millions who have been locked out of the system. They claim the moral high ground, positioning themselves as champions of access to justice. On the other side, you have the establishment, the American Bar Association, and the state bars that regulate the profession. Their argument is rooted in a single vital principle: consumer protection. For over a century, the law has been a protected profession for a reason. The rules against the unauthorized practice of law were designed to stop unqualified charlatans from giving bad advice that could ruin people's lives. A lawyer has a fiduciary duty to their client. They are bound by a strict code of ethics. They have malpractice insurance. If they mess up, you have recourse. They can be sued. They can be disbarred. The establishment asks a chilling question: who do you sue when an algorithm gives you bad legal advice? You can't disbar a piece of code. They warn that in the rush to make law cheap and easy, we are sacrificing the nuance, the human judgment, and the ethical accountability that lie at the heart of the profession. It's a battle between access and protection, between innovation and tradition. And for the longest time, tradition was winning. State bar regulations were an impenetrable fortress, keeping non-lawyer competition at bay. But now the walls of that fortress are starting to crumble. The first cracks appeared not in California or New York, but in a place you might not expect: Utah. In 2020, Utah launched something revolutionary: a regulatory sandbox for legal services. Think of it as a controlled experiment. Inside this sandbox, the old rules don't apply. Tech companies, accountants, and other professionals are allowed to try new ways of delivering legal help, even if they are owned and operated by non-lawyers. They can use technology and new business models to tackle common legal problems, from debt collection to divorce, without the traditional constraints. Arizona quickly followed suit, completely eliminating its ban on non-lawyer ownership of law firms. This is a seismic shift. It's not just about a new app. It's about fundamentally changing who is allowed to solve a legal problem. Imagine a company that uses a combination of paralegals, social workers, and sophisticated software to guide people through the family court system for a low, flat fee. Inside the sandbox, that's not just possible. It's encouraged. It's the legal world's equivalent of allowing a highly trained nurse practitioner to handle routine medical care, freeing up surgeons for complex operations. The goal is to see if these new models can provide services that are just as good, or even better, than the traditional model, but at a fraction of the cost. The early results are promising, showing these new providers can resolve legal issues faster and more affordably for thousands of people. Let's make this real. Meet Sarah. She's an aspiring entrepreneur who bakes incredible artisan bread. She wants to turn her passion into a small business, selling online and at local farmers markets. 10 years ago, her path was clear but expensive. She'd need to research and find a small business lawyer. She'd have a consultation, then pay that lawyer somewhere between $2,000 and $5,000 to form an LLC, file a trademark for her brand name, Sarah's Hearth, and draft some basic contracts for her suppliers. For someone just starting out, that cost is a massive hurdle. It could be the difference between launching her dream and letting it die. Now let's look at Sarah's journey today. She goes online. For $299, a service like Stripe Atlas or a competitor incorporates her LLC in Delaware. For another few hundred, a different platform uses AI to conduct a trademark search and files her application with the U.S. Patent and Trademark Office. It generates standard supplier and vendor agreements for her based on a questionnaire she fills out. In less than a week, for under $1,000, her business is legally structured and protected. She never speaks to a lawyer. Her dream is alive. This is the incredible promise of the new system. But it also carries a hidden risk. What if the automated trademark search missed a small, local bakery in another state with a similar name, creating a legal time bomb that could explode years later? What if the boilerplate supplier contract she downloaded doesn't have a specific clause protecting her from a sudden price hike on flour, potentially bankrupting her business? A human lawyer, one who took the time to understand her specific business and her anxieties, might have caught those things. The AI-driven, productized solution is built for the 80% case. But what if Sarah is in the 20%? She traded the bespoke, expensive protection of a traditional lawyer for the speed and affordability of a platform. Was it the right choice? The terrifying answer is, she won't know until something goes wrong. This is the profound change happening beneath the surface. Law is transforming from a service into a product. It's shifting from a relationship to a transaction. For centuries, the law was an artisanal craft, practiced by experts who tailored their advice to the unique contours of each client's situation. Now it's becoming a scalable, data-driven industry, where solutions are designed for mass consumption. In this transition, we gain unprecedented efficiency, affordability, and access. But we risk losing something intangible and deeply human: the wisdom, empathy, and creative counsel that a machine, no matter how intelligent, may never be able to replicate. The new system is here, and it's making legal help available to more people than ever before. The question is no longer if this will change the world, but what kind of world it will create. And more importantly, who will be in control? Will it be the tech behemoths, optimizing for user acquisition and shareholder value? Or can the legal profession itself harness these incredible tools, reinventing itself from within to deliver justice that is not only smarter and faster, but also more human? The answer to that question will define the next century of American law. It's a battle for the soul of the system, a high-stakes contest between two radically different visions of the future. Let's call them the platform and the profession. First, imagine the platform. This is the future envisioned by Silicon Valley. It's sleek, user-friendly, and ruthlessly efficient. Think of it as an app store for justice. Need a will? There's an app for that. A simple divorce? Swipe right. A contract dispute? A subscription service will handle it for a low monthly fee. In this world, legal services are a product, democratized and available to all. Just like streaming music or ordering a ride. The friction is gone. The intimidating law offices, the confusing jargon, the terrifying billable hours, all replaced by a clean interface and predictable pricing. Amazon, Google, or some yet unnamed startup could become the primary gateway to the legal system for the average American. They would leverage vast amounts of data to automate document creation, predict case outcomes with startling accuracy, and connect users to the most efficient legal provider, which might be an AI, a paralegal, or only if absolutely necessary, a human lawyer. The promise is undeniable. A world where access to legal help is no longer a privilege of the wealthy, but a utility available to everyone with a smartphone. But there is a profound and perhaps terrifying cost to this convenience. When justice becomes a product, it is optimized for profit, not for fairness. What happens to the cases that don't fit the algorithm? The messy, unprofitable human stories? The fight for civil rights, the challenge to a powerful corporation, the defense of an indigent client? These aren't clean, scalable transactions. They are costly, time-consuming, and unpredictable. A platform optimized for shareholder value has little incentive to take them on. And what about the data? These platforms would amass the most sensitive information imaginable about millions of citizens, their disputes, their finances, their family secrets. Who owns that data? How is it protected? How is it used? The lawyer-client privilege, a sacred pillar of our legal system for centuries, could be reduced to a hyperlink at the bottom of a terms of service agreement that nobody reads. The biggest danger, however, is more subtle. An algorithm trained on past legal data will inevitably learn the biases embedded within that data. It will learn that certain neighborhoods are policed more heavily, that certain demographics receive harsher sentences. The platform won't see this as a historical injustice to be corrected. It will see it as a pattern to be replicated for maximum efficiency. It risks creating a system that launders our worst societal biases and presents them back to us with the unassailable authority of computer code. Now let's consider the alternative, the profession. This is the future where the legal community itself leads the technological revolution. In this vision, technology is not a replacement for human lawyers, but a powerful tool to augment them. It's about building a better toolkit, not a different system. Imagine public defenders, historically overworked and under-resourced, using AI to instantly analyze thousands of pages of discovery documents, leveling the playing field against well-funded prosecutors. Picture judges using sophisticated data analytics to understand and correct sentencing disparities in their own courtrooms, ensuring that justice is blind not just in theory, but in practice. Think of small-town lawyers using virtual reality to conduct depositions or cloud-based platforms to manage their practice, allowing them to offer affordable services to their communities and compete with massive, multinational law firms. In this future, the core ethical obligations of the profession remain intact. The lawyer is still a fiduciary, a counselor, an advocate whose primary duty is to their client, not to a quarterly earnings report. The goal is to use technology to enhance human judgment, to free lawyers from rote, repetitive tasks so they can focus on what they do best. Understanding a client's story, crafting a persuasive argument, showing empathy, and navigating the complex, gray areas of human conflict. The promise here is one of evolution, not demolition. It's a future that preserves the essential humanity of the law while harnessing technology to make it more accessible, affordable, and just. But this path is fraught with its own perils. The legal profession is a deeply conservative institution, shackled by tradition and slow to change. The billable hour, for all its flaws, remains the dominant business model, creating a powerful disincentive to adopt technologies that increase efficiency. State bar associations tasked with regulating the profession often move at a glacial pace, stifling innovation with outdated rules that were written for an analog world. There is a very real risk that the profession will fail to adapt quickly enough, creating a vacuum that big tech is all too eager to fill. This could lead to a dangerous two-tiered system of justice: a premium human-led service for the wealthy and a low-cost, automated justice bot for everyone else. The very inequality that technology promises to solve could become even more entrenched. This isn't a theoretical debate. This battle is already being waged in courtrooms across America, and the front line is a technology known as predictive justice. For years, judges have been using risk assessment algorithms to help make crucial decisions about bail, sentencing, and parole. The idea is simple and seductive. Use data to predict the likelihood that a defendant will commit another crime. Proponents argue these tools are a powerful antidote to human bias. A judge might be tired, hungry, or harbor unconscious prejudices. An algorithm they claim is objective. It looks at the data, criminal history, age, employment status, and produces a simple risk score. Low risk, release on bail. High risk, keep them in jail. It promises a more consistent, data-driven, and ultimately fairer system. But in 2016, the investigative journalism outlet ProPublica decided to put one of the most widely used algorithms, called Compass, to the test. What they found was explosive. The algorithm was spectacularly wrong in its predictions. But more disturbingly, it was wrong in a deeply biased way. The formula was twice as likely to falsely flag black defendants as future criminals as it was white defendants. It was also twice as likely to incorrectly label white defendants as low risk. A white man with 2 prior armed robbery convictions was rated as low risk, while a black teenager with a few misdemeanor shoplifting offenses was rated as high risk. The algorithm wasn't eliminating bias, it was automating it. It was taking a system already riddled with racial disparities in policing and prosecution, learning those patterns, and then codifying them into a supposedly neutral score. This exposes the fundamental flaw at the heart of so much legal AI: the black box problem. Often, the creators of these complex algorithms cannot fully explain how they arrive at a specific conclusion. The calculations are buried in millions of lines of code and complex neural networks. This is a direct assault on one of the most basic principles of American justice: due process. How can you challenge a decision if you can't understand the evidence or the reasoning behind it? If a judge sentences you to a longer prison term based on a high-risk score, you have a right to know why. But what if the answer is just, "The computer said so"? You can't cross-examine an algorithm. You can't ask it to check its own biases. It's an unaccountable witness, a silent accuser whose judgment can alter the course of a human life. This forces us to ask a much deeper question: what is the purpose of our justice system? Is it merely a machine for calculating probabilities and managing risk? Or is it something more? justice has always been about more than just data points. It's about context, about narrative, about mercy. It's about a judge looking a defendant in the eye and weighing not just their past crimes, but their potential for redemption. It's about a jury of peers listening to a human story and making a human judgment. An algorithm can calculate the statistical probability of recidivism, but can it understand remorse? Can it appreciate the complexities of a life lived in poverty? Can it weigh the impact of a prison sentence on a family and a community? By outsourcing these uniquely human decisions to a machine, we risk hollowing out the very soul of the law, replacing the messy, compassionate, and aspirational process of justice with the cold, sterile, and unforgiving logic of an algorithm. And that unforgiving logic is no longer a distant science fiction concept. It's here. It's being used in courtrooms across America right now, and it's called a risk assessment score. Imagine you're standing before a judge. Your future, your freedom, hangs in the balance. The judge looks down not just at a case file but at a number. A single digit or a score out of 10 generated by a piece of software. This number claims to predict the future. It claims to know with statistical certainty whether you will commit another crime. And based on that number, the judge might add years to your sentence or deny you parole. This isn't a hypothetical. This is the reality for thousands of Americans. And it's one of the most dangerous and controversial frontiers in legal technology. To understand the profound danger, let's talk about a man named Robert. This isn't his real name, but his story is tragically real. A composite of cases that have played out in states like Wisconsin, Florida, and California. Robert was arrested for a nonviolent drug offense. He had a minor record from his youth, but for the past decade he'd been clean, held a steady job, and was raising a family. He made a stupid mistake, a relapse he deeply regretted. He pleaded guilty, expecting probation, maybe a short stint in county jail. His lawyer thought that was a reasonable expectation, but then the algorithm weighed in. The pre-sentencing report included a score from a popular risk assessment tool. The score labeled Robert as high risk for reoffending. The judge, citing the objective, data-driven nature of the score, handed down a sentence far harsher than anyone anticipated. Years in state prison. Robert was stunned. His family was devastated. His lawyer was mystified. How could a man who had turned his life around be flagged as a high-risk recidivist? The answer wasn't in his actions. It was in the data. So what is this software? And how did it get it so wrong? One of the most well-known tools is called COMPAS, which stands for Correctional Offender Management Profiling for Alternative Sanctions. To generate a score, the software doesn't analyze the specifics of the crime itself. Instead, it asks the defendant a battery of questions, 137 of them to be exact. Questions like, did a parent ever have a drug or alcohol problem? How many of your friends are taking drugs illegally? How often did you get in fights at school? Was your father ever arrested? And crucially, how many times have your friends been arrested? Think about those questions. They aren't about what you did. They're about your father, your friends, your childhood, your neighborhood. The algorithm takes these answers, combines them with your criminal history, and crunches them through its model to spit out a risk score. The intention, at least on the surface, seems noble: to replace subjective human gut feelings with objective, evidence-based analysis. To create a fairer system. But the road to technological dystopia is paved with good intentions. The fundamental catastrophic flaw is that these algorithms are trained on a world that is already deeply unfair. They are built on historical arrest data. And what does that data show? It shows decades of biased policing practices. It reflects the fact that a black man in a poor neighborhood is far more likely to be stopped, searched, and arrested for minor offenses than a white man in a wealthy suburb, even if they're committing the same infractions at the same rate. The algorithm doesn't know this history. It doesn't understand context, systemic inequality, or racial profiling. It just sees a pattern. It sees that people from certain zip codes with certain family histories, who answer the questions in a certain way, are arrested more often. So, it learns a simple, brutal lesson: if you look like the people who have been arrested a lot in the past, you are a high risk. The algorithm doesn't learn to predict crime. It learns to predict who gets arrested. And in America, those are two very different things. An investigation by the news organization ProPublica in 2016 blew the doors off this issue. They analyzed the COMPAS risk scores for over 7,000 people arrested in Broward County, Florida. What they found was staggering. The algorithm was twice as likely to falsely flag black defendants as future criminals as it was white defendants. It was also twice as likely to incorrectly label white defendants as low risk when they actually went on to commit more crimes. The system was not only inaccurate, it was inaccurate in a racially skewed way. It was perpetuating the very biases it was supposed to eliminate. When Robert's algorithm flagged him as high risk, it wasn't because of who he was. It was because his demographic data, his zip code, his family background, the fact that he grew up in a heavily policed community where his friends were frequently arrested, fit a pattern of historical inequality. He was being punished not for his own future actions, but for the statistical shadow of his past and his community. And here is where it gets truly terrifying. This is the part that should send a chill down the spine of anyone who believes in the American legal system. When Robert's lawyer tried to challenge the score, he hit a brick wall. The company that makes the software claimed the underlying code, the specific calculations and weightings that led to Robert's score, was a trade secret. A proprietary algorithm. They refused to reveal it. This is what's known as the black box problem. A piece of code is making a life-altering recommendation, a recommendation that can strip a person of their liberty for years, and the defendant is not allowed to see how that decision was made. They can't question it. They can't confront their accuser, because their accuser is a secret proprietary algorithm. This is a head-on collision with one of the most fundamental principles of our legal system: due process. The right to a fair trial, the right to challenge the evidence against you. How can you challenge evidence that you're not allowed to see? How can you cross-examine a line of code? The answer is you can't. And so, we've created a system where private companies are selling secret justice to our government. We are allowing a person's freedom to be determined by a corporate asset, shielded from public and legal scrutiny. This isn't just a bug in the system. It's a fundamental corruption of its core principles. The implications are enormous. This technology creates a devastating feedback loop. The biased algorithm flags people from a certain community as high risk. This leads to harsher sentences and more intense post-release supervision for them. Because they are watched more closely, they are more likely to be arrested for minor parole violations, which in turn generates more data proving that the algorithm was right all along. The prophecy fulfills itself. It creates an algorithmic prison, a high-tech version of redlining, where entire communities are permanently branded as high risk, not based on their individual actions, but on the data-driven ghost of systemic bias. It's a way to launder our historical prejudices through the clean, sterile language of data and technology, making them seem objective, scientific, and therefore unchallengeable. But the story doesn't end there. The fight is on. Lawyers, civil rights organizations like the ACLU, and data scientists are pushing back hard. They are filing lawsuits demanding transparency and showing judges and lawmakers the deeply flawed science behind these scores. Some jurisdictions, after seeing the evidence, have started to abandon or severely limit the use of these tools in sentencing. They're recognizing that you cannot automate justice. You cannot outsource moral judgment to a machine, especially when that machine has been trained on the very worst parts of our own history. The debate is raging right now in state houses and courthouses across the country. What is the proper role of the algorithm in the courtroom? Can we design a tool that is genuinely fair, transparent, and unbiased? Or is the very idea of predicting human behavior a fool's errand that will inevitably lead us down a dark path? The answer to that question will define the future of American justice. It forces us to confront not just the limits of our technology, but the persistent and uncomfortable truths about the society that technology reflects. Because the algorithm, in the end, is just a mirror. And right now, many don't like the reflection it's showing us. The challenge isn't just to fix the code, it's to fix the world the code is learning from. And as we grapple with these automated judges, another figure is quietly entering the legal arena, not to pass sentence, but to stand beside the defendant. An AI that isn't a judge, but a lawyer. A tireless, data-driven advocate that could change what it means to get a fair defense forever.